Good afternoon, everybody. My name's Andrew Swirling. I'm here with my partner, Salvatore Puccio. We're partners at the law firm of Garfunkel Wild, and we're privileged to give today's webinar, Legalized Medical and Recreational Marijuana, Navigating the Ever-Shifting Landscape for Employers. As many of us have known for a bunch of years, the legalized nature of marijuana, whether it's in its medical marijuana form or recreational form, has been a growing trend going back a couple of decades at this point. But the evolution of the legalization across the country anyway has been pretty inconsistent as far as what is accepted, what's not accepted, what's enforceable or not enforceable if you're an employer. The case law was pretty much all over the lot. If you were a lawyer here in New York, New Jersey, Connecticut, trying to understand what the trends were as the legalization issue approached the tri-state area. You saw certain patterns, but certainly in the last 5 or 6 years, those patterns are starting to crystallize. Still a lot of murkiness, as Sal and I are going to explain to you as we walk along through this webinar. And hopefully by the time we finish today's session, there'll be greater clarity on your part on what your rights are as an employer, what your obligations are as an employer, what traps to avoid, how the landscape has changed from the past. If I can loosely call it, it was a pro-employer landscape, before recent times. Recent is defined by the last 5 or 6 years when medical marijuana was legalized in the tri-state area, and more recently, recreational this year. So we're going to cover a lot of ground today. There we go. But I'd be remiss if I didn't tell you a little bit about Sal, a little bit about our law firm. Sal and I have decades of experience as employment lawyers. We wear 2 hats. We're litigation attorneys and we're employment lawyers, which means we try cases and we give day-to-day counseling. We give training sessions like this in the tri-state area. And wearing 2 hats gives us a somewhat unique status in that when we try a case, we see how a client has handled the situation rightly or wrongly, and then we use that information to inform our day-to-day counseling to try and problem solve before problems become of such magnitude that a litigation erupts. And in part, that's one of the goals of today's session. With regard to Garfunkel Wild, judging from the registration list, we're familiar with a lot of you and have worked with many of you. Pertinent to today's talk, we have a robust employment law practice group. With regard to the subject of cannabis, when medical marijuana became legalized, Sal and I were heavily involved with regard to how that played out among our clients. So the phone started ringing in the last 5 or 6 years with regard to medical marijuana. Now with recreational marijuana, the phone's ringing even more on the what to do, how do we handle it, issues of testing and the like, and how to navigate. What I will say with regard to today's program, in terms of objectives, if Sal, you want to just turn to the next slide. In terms of the broad overlay, what we're going to go through with you is what's the atmosphere, what's the trends. We're going to go through a couple of examples that show up with a fair amount of regularity to help you game plan as these scenarios may confront you on a daily basis. And we're going to give you some practical advice on how to handle your particular place of employment, whether it has to do with your handbook and policies, whether it has to do with marijuana testing, whether it has to do with how you train your supervisors. And hopefully you'll walk away with some key takeaway points with regard to that. I will stress, and for those of you who have been in the audience for the many webinars that we've done over the years, Sal and I, we love questions. You're not going to derail us. You're not going to throw us off. We prefer taking them as we go along. You can wait till the end, whatever your comfort level or preference is. We're fine with it. If you type them in on the screen, we'll see them at this end. We'll try and stay on top of that and answer the questions to the best of our ability. So with that introduction in mind, we'll start heading into the substantive matter. Sal?
All right, thank you, Andrew. I appreciate it. Thank you all for being here with us today. Andrew and I have done a bunch of these presentations over the course of the last 5 or 6 years. And, I think we're finally getting to the point where we can say there's a little bit more clarity, at least for me in this terms of this presentation. There's a little bit more guidance that we have out there now in terms of what can and cannot be allowed on an employment perspective. That said, we're still dealing with the issues because as lawyers, we tend to read statutes a little bit differently. So we have to ask for guidance and interpretation from New York State, the Department of Health, and those folks that have drafted these to help us understand what exactly they're looking to implement. So, and for us, one of the ways it was helpful for us to understand this and learn it is just a quick history lesson in terms of the federal overview. And the reason for that is because many people might think, well, I've been paying attention to the news in the tri-state area, and New York, New Jersey, and Connecticut have all legalized recreational marijuana. So what? That's great. It's legal. Everybody can use marijuana, and these are what the employees are going to say to you. And believe us, we're getting these emails already from clients where employees know the laws better than anyone, because they're ready to start rolling out and using their vape pen and participating in use of marijuana in their at-home lives. And while it is going to be allowed, there are some restrictions that still apply, and it's important for you to understand and balance those as you deal with your day-to-day atmosphere and employment counseling. So just a quick history here, the federal overview. Under the Federal Controlled Substance Act, marijuana continues to be a Schedule I controlled substance. So what does that mean? Definitionally, it means it has a high potential for abuse, had no currently accepted medical use and treatment in the United States, and there's a lack of accepted safety for use of the drug or other substance under medical supervision. Well, if anyone's been paying attention the last few years, that definition doesn't really hold true. We can debate the potential for abuse, but let's leave that to the side. There are accepted medical use, and there are a number of states that use marijuana and allow marijuana to be used to treat medical conditions. So actually, as far back as 1970, Congress studied marijuana. They determined it was not a Schedule I controlled substance for some of the reasons we just mentioned. And many of our healthcare providers that are joining us today, some folks agree, believe. I've spoken to many physicians on both sides, but I think there is some guidance out there and support that medical marijuana or marijuana in general does help some medical conditions. So again, it kind of takes it out of that definition. But what we've seen is a little bit of a seesaw with respect to, well, what are we going to do with enforcing it? It continues to be a Schedule I controlled substance, so it's illegal at the federal level. That has ramifications all the way down to you cannot use a credit card to purchase it, or because banking institutions cannot insure it, it would be a violation of federal banking law. So you can't use a credit card to buy marijuana, even from legal medical establishments in New York, New Jersey, Connecticut, or other recreational facilities. 2009, there was a memo put out that relaxed enforcement. Basically what they talked about throughout that memo was, and memos that followed that, there were supplemental ones in 2013 and 14, which more or less said, if a state has a program in place that's going to adequately address use of marijuana and limits it and tailors it to how they see fit, we're not going to step on their toes. We're not going to come in and get in the way and say that medical marijuana program in New Jersey is illegal. So that was the status for a long time. In 2018, former Attorney General Sessions placed an emphasis on illegal use of marijuana and a crackdown, and there was no crackdown. We didn't see anything. Nothing happened. In fact, crackdown. The prosecutions have been down 20%, according to statistics. Fast forward, where does that get us within the last year or so? Well, in December 2020, House passes a bill to legalize marijuana. It's the MORE Act, Marijuana Opportunity Reinvestment and Expungement Act. It has not been passed. It's still sitting out there. Obviously, there's a lot of other legislation that Congress is dealing with in terms of the COVID pandemic and other crises that we're dealing with. So this is kind of fallen to the background. There was some question about how President Biden would handle this, assuming it got through the Senate. Would he accept it and pass it? And it's a little up in the air, but more or less reading through the tea leaves, what everyone seems to at least accept is that President Biden will not veto it. He'll sign it. While he may not be a staunch supporter of legalizing marijuana at the federal level, the likelihood is it will be passed at some point. And that takes us now to state overview. And one thing I'll just add, and this was interesting in and Andy and I find this stuff interesting, at least on our end. But just yesterday, an article came out because there was a decision for the Supreme Court, and Justice Clarence Thomas, one of the more conservative justices on the court, issued a dissent. It's not the law of the land, but he basically put out a dissent on a topic that involved use of marijuana. And the gist of it was, we don't have to get into legalities, but he said, states are dealing with this already. We have so many states out there, and as I've listed here, 33 states have legalized medical marijuana programs in some form. And that might even be higher, depending on if we factored in some of the different versions of what's allowed with CBD and THC. So we're very close. You see 47 states, have some form of legalization. And what Judge Thomas basically said is, states are dealing with this. It's not getting in the way of the federal government. We have all these memos saying we're not going to enforce it, so let's relax it. So then that takes us to, okay, that kind of clears up if it's going to be legal or illegal, but that doesn't help you, the employers, to determine whether or not you can take action against someone in your employ when they are using marijuana. And this has been a real challenging aspect for employment attorneys to handle, because although all these states had passed laws about legalization, only about 20 states have laws regarding cannabis and anti-discrimination employee protection total. And of those, right now, there's only about 5 that actually protect recreational use. So some examples we always give, and I was speaking with a friend who lives out in Colorado and asking him about his experience over the last 5 years. And they've identified a big gap where in Colorado, for example, one of the first states to legalize marijuana recreationally, they do not have a law that protects employee use. So if you are caught using marijuana and your employer has a policy of no drugs, a zero tolerance policy, even though it's legal to buy over the counter, you do not need a prescription, you can still be disciplined at the office for that, because your employer has a different policy than state law. So that just doesn't seem to make sense, at least to many of us. It doesn't jive, because people might not understand that. Now, though, New York, Connecticut, and New Jersey, we're going to talk about those more, they've started to pass laws addressing that exact issue and providing employee protections. So the reason we're here today is to tell you these laws have changed, will be changing, and now it's important to keep those in mind as you deal with these issues coming up. And that goes back to you now, Andy.
I just want to piggyback off of something that Sal just mentioned about the anti-discrimination laws, because that's a key distinction between New York, Jersey, Connecticut, and some of these other states that don't have anti-discrimination provisions in their statutes that legalize marijuana use. So in those states where you don't have those provisions, employers in certain respects had an easier challenge ahead of them, because if someone showed up and tested positive for marijuana, the employer was able to say, you know what, as Sal told you just before, it's a controlled substance under federal law. It's illegal. It's okay for us to fire somebody, refuse to hire somebody, any form of adverse employment action, because this test shows they're violating federal law, and there's no state statute that prevents us from taking that action. No state statute that would characterize that adverse employment action as a form of discrimination. Very different in the tri-state area with all 3 statutes with regard to protections for employees, which makes it harder for an employer, as we're going to share with you. So where does this leave us now? It's still not permissible to show up at work under the influence. When there were a lot of stories, I'm sure at your places of employment, certainly at this end, the imagery, oh, now that marijuana recreational use has been legalized, the image of people running out at lunch, standing in front of their respective work sites with the tobacco smokers, lighting up and going back into the office. Funny imagery aside, at the end of the day, can't be done any more than, someone is able to go out and have a liquid lunch and show up, drunk, for the afternoon. The difficulty, as we're going to share with you as we go on, has to do with the testing issue. Because if someone shows up drunk and they get tested, you'll be able to tell what their level of impairment is, and also infer from that when they may have started drinking and so on. There's no such testing available for marijuana use. But again, I don't want to give it away before we start talking about it, but that's a complication, all right? But you still can't show up at work under the influence. How to treat off-duty marijuana use, again, that's going to go to, there are certain prohibitions now in place that are pretty firm and clear. There are certain carve-outs depending upon which statute you're talking about between New York, New Jersey, and Connecticut. So there are certain distinctions between the three states that we'll address as well. Again, the testing issue is going to be the key, because that's where employers are going to be hamstrung to a certain degree, and we'll explain what we mean by that. And again, compared to the past, if you had a positive test for a pre-employment screening back in the day, and back in the day wasn't too long ago in the tri-state area, you were able to refuse to hire someone. That landscape has changed in somewhat dramatic fashion. Okay, these are just, to the extent you want to take down notes on the statutes and so on. New York, the Marijuana Regulation and Taxation Act, otherwise known as the MRTA, came out in March. Jersey statutes, February of this year, and Connecticut is the most recent, last week. But again, all three states now have statutes that overlap greatly and legalize the recreational use of marijuana. A couple of small little nits with regard to some of these laws. So for example, New York, the use of marijuana is immediately legal, but the legalization of the sale of marijuana is not expected to commence until 2022, which again raises the issue of, if somebody's walking down the street smoking marijuana of a particular dosage that is legal, well, obviously they didn't purchase it legally in New York, which then raises the issue of where did they purchase it? Was it legal where they purchased it? So there exist technical legal arguments with regard to that person's use, but the practical reality is it's highly doubtful, highly unlikely that law enforcement's going to go anywhere near that. All right. So the New York recreational marijuana law allows adults ages 21 and older to possess, purchase, display, etc., in specified quantities. You can't go above certain thresholds. Again, it takes effect immediately, but the sale is not expected to become legal for another year or so. Important to today's conversation, it's amending Section 201D of the New York labor law to include cannabis within its scope. It now protects an employee's use or consumption of cannabis if it's outside of the workplace, if it's outside of work hours, and you're not using the employer's property or equipment. If someone's at home and they use it, if it's after hours, no different than if they were to go to happy hour at the local bar after work. An employer can't take any form of disciplinary action to the extent they have proof of that employee's consumption. The inverse of it is if it takes place during work hours on the employer's premises, very different outcome. Third bullet, again, to stress, you can't be under the influence at work. A pretty big change in the law is that it allows your employees, if they feel that their rights have been violated, you rely on a positive test wrongly and you fire somebody, they can file a private lawsuit for money damages as well as other forms of relief. The last bullet goes to some of the concerns that people had on, well, what does it mean? Again, the imagery, are they going to be allowed to smoke anywhere? Are they going to be allowed to vape anywhere of cannabis? And the issue is, if tobacco smoking is prohibited in public areas, the same will hold true with cannabis, with some add-ons. And we didn't list them all. There's a laundry list of the add-ons on the places where smoking and vaping of cannabis are proscribed. But for our purposes, places of employment, school property, those are, we consider number one and number two as far as the locations where marijuana could be smoked and vaped. All right, next slide up. Okay, exceptions. And let's face it, if you're an employer, this is what you want to focus on to give you some control over your work site with regard to marijuana use. So where an employer acts upon an employee's cannabis use, there's not a violation of Section 201D if The employer's actions were required by state or federal law, regulation, or ordinance, or other state or federal government mandate. So, for example, if somebody has federal contracts, there are going to be prohibitions against cannabis use. That's part of that particular carve-out, all right? And some of the familiar types or industries, you have Department of Transportation contracts, Department of Defense contracts, Nuclear Regulatory Commission contracts. There are going to be federal contracts of certain types where those prohibitions will remain and will override state law. Or in this respect, be consistent with state law that says that the federal requirements are going to override or preempt. The employee is impaired by the use of cannabis. Again, can't be high at work. Lastly, the employer's actions would require the employer to commit any act that would cause the employer to be in violation of federal law or would result in the loss of a federal contract or federal funding. This one's an interesting one because, again, as Sal pointed out, it's a violation of federal law to use marijuana. So how does that fit here? Our view anyway is that while you have that language there, I wouldn't pin, or we wouldn't pin too much hope on it. It would be different again if you're going to lose funding as a result of, cannabis use. We believe that exception or carve out should be fairly secure, but as far as it being in violation of federal law, we don't believe it to be so. What does impaired mean, at least under the statute? It means that the employee manifests, and this is the important part of the phrase, specific articulable symptoms while working. And then you see the remain that decrease or lessen the employee's performance of the duties or task of the employee's job position or such. And again, focus on that phrase, specific articulable symptoms interfere with an employer's obligation to provide a safe and healthy workplace free from recognized hazards as required by state and federal occupational safety and health law. The use of that language is not, it's a product of careful thought. And what it means is that if someone you believe may be impaired by marijuana use, again, recognizing that the test is not going to give you the information about level impairment at that moment or when they consumed it. So you can conclude, as you would perhaps be able to do with alcohol use, that he or she were smoking on the job. You're going to have symptoms beyond just the test. You're going to have conduct, slurring of the words, certain forms of contact, maybe the scent of marijuana, if a person reeks, for example, because that phrase is going to be something that you can count on, that employees who get caught in the mix with allegations of marijuana use, their attorneys are going to focus on that and have you as the employer or your supervisors, present what those facts are to fit within that phrase.
And just one point to add on to that before we jump ahead, the area where I envision some real debate, discussion, or cases that are going to come out of this with respect to this impairment is going to be, I think we'll be able to spot and determine, as Andy was saying, if there's some impairment in the moment. And we'll give some examples at the end where we've seen this happen already. Someone is under the influence and crashes a forklift in a warehouse, or is under the influence and makes the wrong decision in terms of a medication that's supposed to be prescribed. Those we can identify if we see in real time. The question I have concerns with, and where I think you're going to need to be the most careful as an employer, is when enforcing this rule of impairment, when someone is consistently using off the clock, meaning at night and on weekends, but that extended use is somehow carrying over to the office. And, sometimes we've seen employers say, or you just hear generally, terms like, oh, that person's lazy. Are they a pothead? They don't know what they're doing. They can't follow along. It's killing their brain cells. And I raise these type of issues because it's probably a little bit more of an old school thinking, but it doesn't mean it's not going to show up and be prevalent. And we want to just caution you there because, again, this definition, as Andrew said, is specific. We're really looking for an actual impairment in the time, not something that you're going to look to backdate or say happened over the weekend. But again, it might be possible that it bleeds over to the office. It could just be the person's tired. You know, the person has kids at home or whatever the case may be, and you're not going to be able to pin it on the fact that they've used drugs. But again, you're going to have to balance that because, as Andy said, excuse me, if you make the wrong decision, there's now a private right of action. So jumping to some of the other state laws, Connecticut. And we're really just focusing on New Jersey, New York, and Connecticut today. But Connecticut, this is brand new. You know, the print is still wet. It came down last week. One of our partners out of our Connecticut office, she's been great focusing on this, getting a lot of you know, intel in terms of what's going on at the state level. And about a week before this happened, we kind of expected it and saw it coming and had the slides prepared so we could roll with it. And sure enough, it passed a small margin. So that shows you that there's still not a real majority, you know, or a super majority, I should say. It just barely passed. But again, same thing. We're going to legalize it for individuals 21 years and older. Restrictions on the amounts, where you can maintain it, how it has to be maintained. People are going to need to pay attention to that. But again, not necessarily the employment issue. Retail sales are going to be regulated. They're not ready yet. Same as New York, same as New Jersey. They're going to issue licenses. People are going to have to be certified to do this. And of course, as we all know, the elephant in the room, there's going to be taxes to be collected, right, and shared with the states. That's a big reason these are going forward. So all that has to be worked out. But again, same type of protections. Employers will not be able to take adverse action in Connecticut against workers merely for testing positive for cannabis. You're going to need to find more. There's going to have to be more out there. Again, some carve-outs with respect to, unless it's a violation of some federal restriction that's imposed upon you. And what we really expect there is more Department of Transportation, interstate commerce, things where someone is working or going to be potentially traveling with your product or your services, that will be an actual violation of federal law. That's why we mentioned in the beginning, federal government right now does not seem like they're coming out to your workplace to say it's illegal, you're letting people smoke weed smoke marijuana off the clock. That we don't expect. But again, if you have a contract, something like that, look to that. And this is still very new with Connecticut. We're looking to flesh out all of the details and specifics where there will be some exemptions. You can still prohibit use at work on premises, and allow, you do not have to allow individuals to be under the influence, of course, of cannabis during work hours. So that's going to remain the same. New Jersey, again, more of the same in terms of the enforcement here. It's the Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act, CREAM, or you might see it as CREAMA if they add the A for act, same. But again, you cannot refuse to hire or employ or discharge an individual simply because the person tests positive for cannabis. So again, same concept of adverse employment action due solely to the presence of cannabis in an individual system. Same limitations we're looking at here with respect to violation of federal laws, rules, and statutes. New Jersey's law is a little bit closer to New York's. They seem to be on par in terms of timeline and restrictions and exemptions. So it's a good parallel. If you are looking for some guidance in terms of what to expect, look for one state to the other. And I don't think Connecticut is very far behind. It's just, I don't think it's as close as those two are. So that takes our next topic.
Okay, another overlay, because you have the recreational use statutes in all three states. New York, New Jersey, Connecticut are part of a growing number of states that allow the use of marijuana for medicinal purposes. It's been going on for the last couple of decades. The tri-state area is a little bit more recent. So, for example, New York enacted its medical marijuana statute in 2014. Before the implementation or enactment of the New York recreational marijuana statute, there were specified medical conditions, and they were pretty detailed, where the use of marijuana for medicinal purposes was authorized. The recreational statute amended the New York medical marijuana statute to the extent that it broadened it, rather than limiting it, I should say, to the specified medical conditions, chronic pain, certain types of cancer, and so on. It's now all medical conditions. If you have a practitioner who is a qualified practitioner who can certify the patient and follow all of the protocols in the medical marijuana statute, now you have an employee, aside from permissible recreational use also has a secondary form of protection with regard to the medicinal use of marijuana. So you ask yourself, well, what difference does that make? I mean, don't they just overlap? Doesn't one override the other? If someone can use recreational marijuana and it shows up in a test, a blood test, what difference does it make what form, medical versus recreational, that the employee was using it? And here's the distinction, because if you want to just move it over one slide, Sal, there's protections for the use of medical marijuana. Certified patients, and there's other categories of individuals that will fall under that umbrella, designated caregivers and so on, can't be discriminated against on the basis of the use of medical marijuana. So what does that mean? Well, you have statutory language that now deems a certified patient as someone who is considered having a disability, unlike just a mere recreational user. So what does that mean? Well, if I'm a certified patient, I'm considered as someone who has a disability, which means I have the protections of the laws prohibiting disability discrimination. And that takes it to a different level with regard to workplace protections, because that then triggers an employee's obligation with certain criteria met to provide me as an authorized user of medicinal marijuana with reasonable accommodations relating to my disability. One important caveat to that to keep in mind is that in assessing what may be a reasonable accommodation in this context, dealing with someone who is a certified patient under the medical marijuana statutes, it's important to remember constraints on even a patient's ability to use medical marijuana and the prohibition against the use of approved medical marijuana products in certain places. Again, places of employment, near school grounds, and there's a long list of places where even medical marijuana can't be consumed. Likewise, with medical marijuana, there's prohibitions against vaporizing in public places. So again, there are certain additional protections for someone who is a certified patient, but there are still certain limitations on that person's use as well. So.
So now we're going to switch to another topic, but it kind of brings us a little bit all together in terms of drug testing. Just looking to see if we skipped the slide. 1 second. Yep. All right. So testing under state law is not prohibited, but its utility is questionable. And what we mean by that is you do have to pay attention to local laws with respect to the testing. For example, New York City does have a law prohibiting the testing for marijuana, and you cannot test unless there's a specific reason and there's a certain carve out with respect to vulnerable persons in certain positions and capacities related to safety. Now, again, that law from 2020 predates the 2021 recreational law in New York, so there's a bit of a gap there. We're seeing that already, but still important to pay attention to that. But generally speaking, under the states, you can test for marijuana. There's going to be some specific restrictions with respect to New Jersey and what instances you can test in terms of physical examination. There will have to be some support. You can't just randomly test. But what the concern becomes is the next question: what's the usefulness with testing if I cannot take an adverse employment action? What Andrew and Sal, you just told us is if someone just tests positive for cannabis, I can't go ahead and fire them solely for that. So what's the purpose of testing? Well, we recognize that that is a bit of a change, and the usefulness still is going to have its need or applicability here, in that if it's a safety issue or safety concern. So if there is some reasonable belief that a person is under the influence, or there might just be a policy that if an accident occurs, we're automatically going to do some form of testing, that policy seems to still be okay. In terms of if there's going to be a safety issue. Again, New Jersey, we're going to want to look at it a little bit more carefully to determine if there's some specific reason to want to go that route. New York and Connecticut, a little bit more of a blanket opportunity to test there. But in those circumstances, you might want to test to see if the person is under the influence or was under the influence at the time. The real problem that we encounter here is, unlike alcohol testing, where you can do a breathalyzer, where police officer pulls someone over, they blow into the machine, and it determines what their blood alcohol content is at that moment in time. There's no such test for cannabis that we have. Now, it would be a great invention to come out with. I don't know how they would physically do it. That's for minds far greater than mine. But until we have such a test, marijuana could be in someone's system. Research shows 1 to 30 days. So that person could fail the test theoretically, but have consumed marijuana 29 days ago. What effect is there? Obviously, use of marijuana 29 days before an accident has no effect. So that's why I think, Jersey was looking at this from that perspective and saying the test alone doesn't mean anything. We need to see some actual impairment, right? To use the language from New York. We need to see that in real time the individual was affected. And were there other signs and symptoms that support the conclusion that the person was under the influence at that time? So again, it's a little bit tricky with respect to the testing, what it shows. Where we've seen this play out just recently is individuals have gone for the testing, have tested positive, does not necessarily automatically, again, as we said, make someone ineligible for a position or require that they be terminated. However, it might require, okay, well, you know what, you tested positive, you're in a position that's involved in safety, we're going to place other kind of monitoring in place to make sure that this individual is safe and protecting our patients, protecting our customers, et cetera. So just things to keep in mind with respect to how we're going to see the testing play out.
Okay, before we go to the this case example, there was a question asked, okay, regarding federal funding. When we have a federal grant, like a FEMA grant, the grant requires us to sign that we, quote, adhere to all applicable federal statutes, unquote. Is this enough for us to rely on the federal funding exception and take action on an employee's cannabis use? Excellent question, by the way. Here's the answer, at least as we believe it to be. There's technical interpretations of the law, and then there's pragmatic approaches to what may be technical interpretations of the law. And by that I mean, in this particular context, perhaps there could be an argument along the lines that you're suggesting in your question that, well, I have to write that I'm complying with all federal laws. As Sal mentioned earlier, it's still a controlled substance under federal law. It's still illegal under federal law as of today anyway. We'll see what the year brings. So therefore, I can rely on that and say, well, I can't say yes to that question if I'm allowing my employees to show positive test results for cannabis use. So arguably, you can move forward with that position. But here's a more pragmatic approach. And it gets a little messy, and I'm not going to bore you with some of the case law. There was a lot of case law, Connecticut and so on, Jersey, where courts were confronted with that very issue, where those states came out with medical marijuana laws that had certain discrimination or anti-discrimination provisions. And employers had taken adverse employment actions against their employees, making the pitch of, hey, it's a violation of federal law. You can't stop me from enforcing federal law, and federal law preempts or overrides anything the states want to do. But the courts in those particular cases where there were these anti-discrimination provisions, and all three of the tri-state area states have them, the courts in those decisions came up with legal reasoning, and I'm not going to get granular on that, that said federal law does not preempt state law, and therefore these state provisions, these state statutes that have these anti-discrimination provisions still govern regardless of the illegality under federal law, and therefore the actions of the employers in those particular cases was wrongful, and the adverse employment action had to be undone, and and so on.
And just to jump in on that, Andy, that is an outstanding question, and I think that gets at the heart of some of the gaps that we're seeing, and what we highlighted earlier between, well, why is it so important then that the federal government come around to this? That, Supreme Court decision, that dissent by Judge Thomas, why is that even relevant, Sal and Andy? And the reason is for questions like that. And prime example, I'll give you two quick examples that relate to this. I think it was West Palm Beach, I think it was in Florida, was confronted with this very issue with respect to FEMA, and said, well, we have to, it was legal in that respect. I think it was medical there. I don't think they have the recreational laws in Florida yet, but it was medical legally. And West Palm Beach took the approach that, well, we have to sign off on this grant to FEMA that says exact language quoted, we're in compliance with all federal statutes. Therefore, our firefighters have to test negative, even off duty. And they dug in on that position and they kept it. Now, I think it might be a little bit different in the tri-state area now that we have some actual laws, to Andy's point, that, the states or the federal government even could look to those laws and say, well, those laws are very specific. They're very detailed. If we look at this federal legislation, here's where we fall. Federal guidance, they're saying stay away from the states, leave them alone. One other example that came up, a provider, healthcare provider, Arizona, New Mexico, forgive me, I forget the exact area, but somewhere where it's very dry and hot, came forward and said, I cannot allow individuals to use marijuana, even medically, under the state controlled program, because I get Medicare funding, and Medicare is federal funded dollars to me. So if I collect it, I'd be in violation of the federal laws. The court actually looked at it there and said, no, that's too attenuated. That's not what we're talking about. Your federal funding has no effect on the fact that your office clerk or your biller or collector used marijuana for a medical condition that he or she had. So they actually struck it down there. Again, we just don't know yet if someone put this case, if you had to get the FEMA money out there, where it would fall down. We'd like to think that at least there'd be some good faith basis why you would have an argument. But again, that's where we're going to continue to follow this and see where it goes and stay up to date.
And so if you're asking, what would we advise if this was well, it is a real life question, is regardless of the technical argument that could be made, from a practical standpoint, we would advise in a situation, upon knowing more facts, not to use that as a basis to take adverse action against an employee. Because, given the advent of the recreational use statutes and the anti-discrimination provisions, there's a pretty sharp likelihood that you're going to be buying yourself a costly lawsuit. That could have a ripple effect across the board in your workplace. And so you have to ask yourself, yes, theoretically, you're putting FEMA monies or other monies, Medicaid monies at risk. If they were to look at your workplace and say, aha, you're allowing your employees to use cannabis, and therefore we're going to deny you X funds. Not likely it's going to happen, and not likely it's going to happen for the additional reason. I mean, Sal gave you the evolution of the enforcement history by the federal government, which was no enforcement history whatsoever. The notion that the federal government, where there was the bill in December of 2020 in the House anyway, that they approved to undo the illegality of cannabis under federal law, I don't think that's a real grave concern that all of a sudden your funding's going to run dry if you check the box otherwise. Okay, so the case example, you have a physician, he or she's offered a job at your medical practice. Before they show up, they test positive for marijuana. What do you do? If this was before 2021, you'd have a little bit more flexibility as an employer. You'd be able to say, hey, at the end of the day, it's our workplace, you're positive, we're going to just deny you employment to the physician. Or quite frankly, I know we have the differentiation with the front desk receptionist. While there are different safety concerns, what we would advise in that situation, now that you have the recreational laws that have these anti-discrimination provisions, that have these impacts on the utility of marijuana testing, as Sal described, it handcuffs you as an employer in a certain respect. So what do you do with it? One thing you can do is there are, we're not going to go into heavy detail in this webinar because it can consume a large part of any webinar, if not as a standalone webinar, has to do with under what circumstances are you allowed to test in terms of random testing, across the board testing, and so on. It might be the kind of thing where if you implement certain types of testing, you may end up having a positive result coincide with a situation where that individual shows specific articulable symptoms, okay? So it's a little dicier now on what you can do with that information. And again, part of it has to do, and it goes back to how new the landscape is, and I'll use a silly example to illustrate the point. I'm a brain surgeon, and I test positive for marijuana. And I say, hey, I used marijuana. It's legal to use it under New York law. And I used it 3 weeks ago. I don't do it the night before a surgery. Go prove when I actually consume that marijuana, right? So on the one hand, that physician, that brain surgeon would be on pretty solid footing. On the other hand, and it hasn't played out yet, what will the courts do? Will there be any, so for example, New Jersey doesn't have a safety exception under its statute, unlike New York, for example, okay, which there are certain distinctions under New York law with regard to when you can test, when you can't test. For example, the New York City prohibition against marijuana testing has explicit carve-outs if you're going to care for patients, right? You know what, and again, that predates the legalization of recreational marijuana and the statute that has the anti-discrimination provision. The point being that it's still unclear how these statutes ultimately going to play out with regard to positions that are truly safety sensitive, with regard to positions that affect healthcare or medical care or clinical care, for example. You got to proceed with caution because it's unclear, but we have to just let it play out as well. Sal?
All right, so let's see. So another example, we've kind of touched on this on the fringes, right? But you have an employee operating safety equipment, and they have an accident. Your handbook right now requires drug testing. The test comes back and the individual tests positive for THC, but you can't tell exactly when it was consumed from that test. What do you do? So, you know, as Andy was just saying, it becomes a difficult situation. You have to really balance it out. What we're suggesting is you're going to have to look to other factors, other instances, talk to other staff, other employees, do a full-blown investigation to determine if the individual operating that equipment was showing any signs or symptoms of being impaired. Okay, because again, that's the standard for the most part. If there's going to be a specific issue or something we can point to in real time where the individual showed any type of lapse in judgment, inability to act or react within the appropriate level of that position, to determine if you can take adverse employment action. So this is where it's all getting very new. A year or so ago, this answer was very different. The answer was test the individuals, see what comes back. If it comes back positive and your belief is it affected the operation, you would let the person go. Now, it wasn't as black and white as that, but we were a little bit more inclined to focus that way. Now, we cannot jump to that conclusion because you're going to have to demonstrate an actual impairment. And to be quite honest, this is where there's just a gap in the science and the law, because if that person is on a forklift and you do a blood test and they come back with alcohol in the blood, well, that's a simple answer. We're going to let them go. We're going to terminate them, and we're going to back you on that. They can't operate a forklift, medical equipment, anything under the influence, right? Where cannabis becomes more difficult is it's not going to show up in real time. So again, as Andrew was saying, we have to let this play out a little bit to see exactly where courts will give us guidance and direction in terms of making determinations to limit. You know, again, if maybe you have cameras up in the workplace, and if they can let people know, follow the laws with respect to cameras in terms of recording and non-recording. You know, be careful of that. Be sensitive to that. But if you witness somebody consuming or vaping marijuana, that's one thing. I mean, again, it's so difficult because it could be an edible, it could be a liquid tincture. There's many different forms in which medical and recreational marijuana will come in. Next example, and this kind of goes to some of the questions that we're seeing that we're seeing pop up, and we'll turn to those to the best we can. You guys are testing us with these questions. They're not easy, that's for sure. But this is a scenario we kind of expected. Application is offered to an individual, comes back positive. Now, in this particular case, using the example that's come from our audience here, let's say the individual now is someone who works, and I know we see a lot of substance abuse questions here, providers, maybe OPWDD, or we've seen others where it's mental health facilities where HRA is going to regulate. And how are we going to deal with that situation where the individual who we're hiring is a social worker or is a counselor or is going to be dealing with some quote unquote vulnerable individuals, as that term is defined under the relevant laws. And there are specific definitions with respect to that and impairments that come with that. So that, while it's a little bit different, what we would do is we would guide and direct you to any specific state law to see if there's any restriction. So in other words, if there's a restriction from OPWDD or HRA or some other government agency, another alphabet soup that I'm missing right now, that says counselor cannot consume marijuana or cannot consume alcohol because of the position, well, then you have a state law or regulation that you can rely on. Short of that, though, we had a case that came up very similar to this. The guidance was, well, HRA isn't going to like it. HRA is going to audit us. They're going to look. And if we have a failed drug test for an individual, it's very likely they're not going to give us funding. Well, quite frankly, I don't think HRA should be holding up the funding in that situation. I think that violates the state law. I think now the state is in conflict with its own law, because the law says I can't adversely affect an individual's employment simply because they test positive. How can HRA then say, well, I'm not giving you funding if anyone tests positive? It doesn't work. That said, we certified that question to the Department of Health, and the guidance that came back that we got was that unless there's an impairment, you need to look at the impairment. You can't just have the knee-jerk reaction that someone is using and they're ineligible for the position. So with that guidance, we are a little bit more cautious of just saying, even if it's going to be a counselor or social worker, et cetera, to just discharge the individual, refuse to hire the individual blanketly without more support. So I think it's going to take a lot of effort from unions, trade organizations, groups that you may belong to, where they're going to have to go ask for guidance and petition the state for information on how do we react. Or you're going to have to ask directly to any of the providers or payers who might be submitting reimbursement, are you going to exclude us because of this particular situation? The more difficult question is, and we're still analyzing this, what if your general policy is we want our counselors to be drug-free and alcohol-free? Well, I think that has to be a little bit of an internal reflection to determine you're a substance abuse provider. You understand there might be relapses. You might want to work those out on the fringes to determine if there are second chances. That said, we understand that the role an individual has in shaping the lives of others may not allow that. So all good considerations. Sorry, we don't have a better answer for you. Unfortunately, this is an area where we don't think the law exactly lines up with what's happening and what will be happening from a practical standpoint. So we'll continue to look for guidance. We'll continue to ask these questions. And based on the feedback we're getting here, we'll push this a little bit more on our end to see if we can provide more guidance. Andy, any other thoughts?
Well, to add to what Sal's saying, and it correlates to a couple of the questions that you've all asked. One, is there a list of safety-sensitive positions in healthcare that could be exempted from the law in New York State? The answer to that question is no, but there's another question. What if the physician works at a substance abuse center? What recourse, if any, does an employer have considering employment for a facility which provides treatment for substance use disorders? And these are the types of questions that we've been getting in the last few weeks. Just by way of example, there's a New York regulation that applies in this particular context, and it does not say that the mere fact that you have a positive test for marijuana automatically disqualifies that employee. And I'll just quote from that particular regulation because it goes to answering the particular question that I just read and to the point that Sal's mentioning. It's not enough to have a positive drug test. You need, quote, an assessment that no person shall assume his or her duties unless he or she is free from a health impairment, which is of potential risk to the patient or which might interfere with the performance of his or her duties, including the habituation or addiction to depressants, stimulants, narcotics, alcohol, or other drugs or substances which may alter the individual's behavior. The mere fact that you have a positive test for marijuana doesn't in and of itself create a potential risk to a patient, because again, you don't know when that's consumed. You have no idea about a level of impairment. So it's not going to be enough to satisfy that standard. Likewise, a mere positive test, on a single occasion isn't going to constitute proof that the person has an addiction to marijuana or uses it habitually, okay? So this is an example where even in healthcare, employers are somewhat hamstrung, and how it plays out in the courts, whether or not the courts are going to say it's up to the legislature to fix this or not, again, remains to be seen, because the law is just 5 minutes old.
And, just to that, some of the, the analogies Andrew and I were kicking around in weeks past when coming up with this, if you had a physician that, had an impairment to a hand or the tendon, maybe they had tendonitis or tennis elbow or something like that, well, that's technically a health, condition, right, under the statute, but it might not prevent that individual from performing their services and their duties on a daily basis, might not make it a health risk for the patient, as that regulation talks about. But if that individual, after years and years of time, develops an arthritic condition where they can't open their hand, and you can see on the camera, if my hand is closed, or individuals have tremors and cannot control the tremors, well, now that might be a health risk that's going to affect the patient, and you would look at it a little bit differently. So same thing here, use one day might not be an impairment under these definitions, or might not cause a health risk. So we have to look at it a little bit bigger. And I don't see anything out there that yet blanketly says in this particular category, it's a violation to allow the person to work if they even just test positive. And again, the law is pretty sweeping in that regard. They haven't made those carve-outs. Not to say they won't, but right now we just don't see it.
Exactly. All right, some best practices. Take a look at your existing drug policy to make sure it's updated, because these changes are rather recent. We've been helping clients out in this regard, but make sure that your policy is up to date so you don't have something on the books that can be used against you to the extent you have a problem with regard to this issue. Keep cannabis out of the office. It's no different than alcohol. Treat it the same. You can have a zero tolerance policy for use in the workplace and during work hours. If people roll out during lunch, no different than they can pound down a few at the local gin mill. They can't take tokes outside as well. Stay on top of drug testing methods that are being refined over the passage of time. Again, currently there's nothing that indicates a level of impairment or when the marijuana was consumed, but we're certainly staying on top of those developments. That fourth bullet, speak to a lawyer before you go jumping. Penny wise, pound foolish. Have that conversation before you take that adverse employment action to see what risks you're taking if you step forward based upon the evidence before you. Do you only have a positive marijuana test? Do you have some specific articulable symptoms that you can latch on to? You want to have clarity on that and documentation in your files about that clarity before you step forward. Educate your employees about your drug testing approaches. Do you have drug testing? Do you have random drug testing? Is reasonable suspicion testing? There's certain types of testing that is permitted that you may want to avail yourself to. Maybe not. It may not be practical. It may be impractical in a large scale way, but there is testing that is allowed that you may want to implement. Again, utility is diminished, but there are certain options out there. And train, lastly, your managers appropriately on how to spot signs of impairment. That's a big one. In New Jersey, interestingly, in the statute, there are certain individuals who can be qualified or certified as experts in this particular area in terms of identifying workplace symptoms of marijuana use. There's a whole certification piece and so on. Again, the law is 3 minutes old, so it remains unclear what role those experts will play in the adverse employment action process. what role they're expected to play, what probative value that person's opinion will have in a particular context, but it just reinforces our belief anyway, that training your supervisors on what to see and what to do with facts once they see them is important. And you want to train them so they don't overreact too. They don't start seeing things that, will give, too much weight to certain facts that may not indicate marijuana consumption. Sal?
Thanks, Andy. Just to follow up on those points, timing here is everything. We had a call yesterday with a client. It wasn't on this topic, but it was about some handbook issues. And as I looked through the handbook, I just highlighted for them something related to their drug policy and said, you're okay with what you're doing. Their policy was consistent, that it referenced a Department of Transportation, federal drug testing permitted with respect to following Department of Transportation. And in that particular client, they did have individuals who would fall under that umbrella, so it was okay. But the comment I had to them was just make it clear that it's for this category, because what you don't want to have is, and many of your policies may already have in them, we are a drug-free workplace. That's going to technically be a violation blanketly in and of itself right now under these new laws. So you just want to go back and look at those things, because what could happen is an employee could file that private right of action, and we expect litigation to come out of this is individual is showing up for work late, doing a bad job, the typical bad employee you always have, missing assignments, not doing the work correct, not getting it. You're going to terminate that individual at some point in time because you've had enough, because they're not doing their job. The termination will be justified. You'll talk to your attorney, they'll go through it. But there will be the history where this individual tested positive for marijuana at some point, or it came out in a discussion that this individual used marijuana at some point. And they're going to say, you fired me because I used marijuana. And that's illegal under the new New Jersey law, Connecticut law, New York law. And now you're going to be in a position to defend that. And what we always tell clients is document, number one, and document all the transgressions, all the problems, all the tardiness, all the absences. But lo and behold, we understand that's not always your primary focus. You might not have an HR department that's on top of that to do that. You're focused on saving lives in a lot of cases, and we get that. So when that employee comes forward, they're going to point to the handbook and say, see, look, they're relying on this provision that says I can't use drugs. That's not the law anymore. It's old. And look, we can defend it, but it's a lot easier if we have an updated policy. It's a lot easier if you've kind of transition to what the new laws and requirements are in moving forward. So just keep that other example in the back of your mind, where someone and some plaintiff's attorney is going to throw this against the wall and say, aha, I'm going to try to get this to stick. All right, and continue to just stay updated with us, with other articles that you read, other alerts that you get, because we do expect more and more guidance as things evolve and as the recreational marijuana that becomes actually available for purchase and consumption and sale. And if we have any other further questions, our contact information is up. Please be on the lookout for further client alerts from not only Andrew and myself, but our other colleagues in our cannabis group. There are some significant real estate leasing finance issues that are out there. Some publications you can certainly read, but there'll be some future webinars on those. There's going to be more on the more healthcare technical side in terms of what recreational marijuana means for the state, means for providers, means for businesses that are out there. So continue to stay up to date, please. If you are not getting our alerts, let us know. We'll certainly add you or any colleagues that you have to the list. That's always helpful. You're free to skim past them, as many of us do with spam email, but obviously some of the information in the headlines, we try to make the headlines punchy to get your attention, and it might save a lawsuit, might save a bad decision. So it's worthwhile to take 20, 30 seconds to look it over. And of course, it's a free service that we're providing, so take advantage. With that said, thank everybody. Andrew's number is 516-393-2581. The 5 is missing. The good question, good point in the questions. 2581 for those of you taking it down. All right. Thank you so much.
Thanks, everybody. Have a good day.